President of the Court of Appeal, the Honourable Justice Margaret Myrrh AC, the judges of the Supreme Court, judges of the Federal Court, judges of other courts, state and federal, retired judges, members of the legal profession, distinguished guests all. First, I should begin by acknowledging the traditional custodians of the land on which we meet tonight, including the land on which others who are virtually present here tonight are meeting in Cairns, Townsville and Mackay, and pay my respects to their elders past and present. It is my privilege and also my own pleasure to welcome our Speaker, the Honourable Margaret White AO, back to the Banco Court again, and hopefully for a happier occasion than some of the previous occasions on which the Honourable Margaret White has sat here in the past. Tonight, as you know, Margaret will be giving us the Selden Society Australian Chapter lecture on Mabo in the state of Queensland, and it is really difficult to imagine anyone who would be better qualified to give us a lecture on that topic. The Honourable Margaret White AO acted as junior counsel for the Queensland Government in the very lengthy trial proceedings in the Mabo litigation. She does bring a unique and valuable perspective to this landmark common law case. Margaret graduated Bachelor of Laws at the University of Adelaide in 1966. She was admitted as a barrister of the Supreme Court of Queensland in 1978, and she commenced practice full-time at the bar some 6 years later. She was appointed a Master of the Supreme Court in 1990, and in 1992 was appointed as a judge of this court, the first woman to hold such an appointment. She was appointed to the Queensland Court of Appeal in April 2010. Her Honour's long and distinguished contribution is not limited to the law but extends to academia, the armed forces and the community, including membership of the Advisory Committee to the Australian Law Reform Commission on the Judiciary Act, being a Foundation Fellow of the Australian Academy of Law and a member of the University of Queensland Senate, becoming Deputy Chancellor in 2006. Margaret was conferred with an Honorary Doctorate of Laws from the University of Queensland in 2005 and an Honorary Doctorate from the University of Adelaide in 2014. She served as a Commander in the Royal Australian Naval Reserve for some 8 or 9 years and was Deputy President of the Defence Force Discipline Appeal Tribunal from 2008. Close to home, she was a Distinguished Chair of the Supreme Court Library from 1999 to 2003. She served on the committee and was National Chairman of the Winston Churchill Memorial Trust, and she's currently a Counsellor of the Australian National Maritime Museum. In addition, if that doesn't make us feel tired enough, she's, amongst other roles, now serving as a Royal Commissioner in the Northern Territory, as you all know. I now ask Margaret to give us the lecture on Mabo. Thank you.
Thank you, Chair. Your Honours, ladies and gentlemen, may I too acknowledge the traditional custodians of the land where we meet this evening, the Turrbal people, and pay my respects to elders past and present. May I particularly acknowledge the elder women as custodians of their law. I'm honoured by the presence of Torres Strait Islander people in Cairns, and amongst them, may I particularly acknowledge Ms. Narita Davis, niece of the late Eddie Mabo. and may also acknowledge this evening Ms. Margaret O'Donnell, the wife of former Justice Martin Moynihan, who will be mentioned rather a lot this evening, and his daughter Catherine Moynihan, as well as a number of people who played important parts in the Mabo litigation, who are here this evening, sort of for old time's sake, I suspect. May I also express my considerable gratitude to Ms. Miriam Moss and Ms. Mary Healy from the library for their assistance with the preparation of the PowerPoints. Like another Selden lecturer earlier this year, it's not my greatest strength. When you came in, you might have heard some music, some singing. You might have thought perhaps I was playing Gregorian chant, but in fact, it was a recording made in about 1967 of elderly men on Murray Island singing their old songs. They were recording them for Mrs. Margaret Laurie, who was a witness during the Mabo trial of the facts. She recorded their stories at their request, and she also recorded some songs, and we've been able to have those played to you. It would have been nice, but I think not entirely easy to achieve, to have put alongside that some singing by elderly informants of Professor Haddon, of whom you're going to hear more this evening, which is held in the British Library collection and recorded in the 1890s and held on wax records. Now, I have no doubt at all that the decision of the High Court of Australia, handed down on the 3rd of June 1992, bearing the name Mabo against the State of Queensland No. 2, is amongst a small number of legal decisions which has had a profound effect on this country. If, as one commentator put it, Mabo is just a case about 3 very small islands, then Engineers was just a case about a small industrial dispute in a Western Australian railway yard. Noel Pearson, launching Mabo, what the High Court said, in January 1994, observed, "We don't have a strong tradition in this country of judgments of the High Court pervading, in a social sense, the fabric of the country. But we'll be talking about Mabo and its importance historically for a long time to come." The decision has generated a huge number of academic treatises and articles. The National Library records 465 books about the Mabo decision and has digitised 1,161 newspaper articles, as well as 2,631 journal articles. It occupies much of any university course on land law and is commemorated each year with considerable festivity, particularly among Torres Strait Islanders in Townsville, which had been Eddie Mabo's home for most of his life. By any measure, this is an important case. Two films have been produced about the litigation, one in 1997, a documentary, and the other in 2012, a docu-biopic with well-known Australian actors playing the lead roles. I must say, I did think that Ms. Miranda Otto was a little mature for the role she was asked to play. The decision was much anticipated, and when it was delivered, it created a tremendous rumpus and remained a major topic for popular discussion for months in newspapers and public affairs magazines. Every anniversary of its delivery is remembered somewhere in the popular press. Dr. Brian Kean Cohen QC, the lead counsel for the plaintiffs throughout the trial of the facts, has written his memoir entitled Mabo in the Courts. he has deposited all of his papers relating to the litigation in the National Library of Australia, which, together with the Mabo family papers, has been inscribed on the UNESCO International Memory of the World Register as documents of unique and irreplaceable world significance. Now, I quarrel with some of the detail, and I'm a little wounded that Queensland counsel are described as operators, but the book is as exhaustive an account of the litigation as any but the most obsessive could want. Since the passage of the Native Title Act in 1993, many federal court judges have become experts in the analysis of evidence about native title, including an extensive exposure to anthropological evidence. I would not presume to enter that field. My ambition this evening is more modest. I want to say something of the historical context and circumstances of the litigation, how it developed, and how the evidence was gathered. I'll discuss the reasoning of the High Court, consider the consequences of the decision, and finally, make a few observations about the man whose name is forever perpetuated by this case. Before doing so, let me briefly outline what the plaintiffs sought. On the 20th of May 1982, Eddie Mabo, his aunt Saluia Mapo Sali, Sam Passy, his brother, the Reverend David Passy, and James Rice initiated proceedings against the State of Queensland and the Commonwealth of Australia in the High Court's original jurisdiction. They brought the action on their own behalf and on behalf of the members of their respective family groups. The second plaintiff, who was Eddie Mabo's aunt, died in 1985 before the remitter, and in the course of the hearing, Sam Passy withdrew from the proceedings, largely because of the divisive nature of the litigation on Murray Islanders and some apprehension about costs if there were an adverse outcome. The Commonwealth was struck out as a defendant in 1989, essentially because the plaintiffs discontinued their claims to seas and reef. The plaintiffs contended that since time immemorial, their ancestors, and thus they, had owned and had occupation rights in particular areas of land on the Murray Islands, the surrounding sea and seabeds, and reefs in accordance with their laws, customs, traditions and practices, and that the annexation of the islands by Queensland in 1879 was subject to these rights of their predecessors in title. They sought various declarations to that effect. Importantly, the plaintiffs sought declarations in respect of particular plots of land or with respect to the seabed, seas and fringing reefs allegedly owned by those individuals and their family groups. Ultimately, 36 blocks were claimed by Eddie Mabo, 6 by Dave Passy, and 4 by James Rice. They did not seek any declarations about their rights by virtue of any overall community interest in the land, which had been the usual case where native title was recognised by the common law. On the 27th of February 1986, the Chief Justice, Sir Harry Gibbs, remitted to the Supreme Court of Queensland for hearing and determination all issues of fact raised by the pleadings. The plaintiffs had sought remitter to the Federal Court, but His Honour concluded that since the dispute was about land in Queensland and only the presence of the Commonwealth gave rise to federal jurisdiction, and since the rules of court were much the same, the State Court was more appropriate. Issues of law consequent upon the determination of the remitted issues of fact were reserved for the High Court. I should say that there is some misconception by some that the case heard in the High Court was by way of appeal. It was not. Counsel appeared before the senior puisne judge in Brisbane for allocation of a judge to hear what was then regarded as a very long trial of some 4 to 6 weeks. His Honour ruminated upon the available judges, and, such are the vagaries of life, having 3 available, Justices Connolly, De Jersey and Moynihan, he chose Justice Moynihan. The plaintiff's counsel objected to Justice De Jersey on the basis that as counsel he had regularly been briefed for the State Crown. The Murray Islands, Myrrh, Dower and Wyre, lie at the eastern end of the Torres Strait. It is a stretch of water containing hundreds of small islands, few of which are habitable. The shortage of potable water has been a constant problem. The islands of the Strait have tended to be classified into 3 groups, not just since the arrival of Europeans in the 17th century, but reflected in their own distinct languages and habits. They are the Western Islands, which include Thursday Island, for approximately 150 years the administrative headquarters of the Torres Strait, the Central Islands, built upon coral quays, and the Eastern Islands comprising Ugar, or Stephen, Erub, or Darnley, and Myrrh, or Murray, with its 2 subsidiary islands. Myrrh lies between the coast of Papua and Cape York at 10 degrees latitude and 144 degrees longitude. If a line were notionally dropped from Myrrh, it would reach approximately west of Charleville in central Queensland. The Murray Islands lie close to the northern end of the Great Barrier Reef. There's a picture from the air flying in. That's the wing of the plane you can see at the top, not bad photography. The Murray Islands are volcanic in composition with fertile soil, which allowed a strong gardening culture to develop, unlike the other islands, which depended almost solely on fishing, particularly dugong, for their subsistence. The main island of Myrrh has an area of just over 4 square kilometres, with its highest point, the long-extinct volcano Gillam, rising 234 metres. The history of Murray Island prior to annexation in 1879 was an important part of the fact-finding process because the plaintiffs needed to prove that they had exclusively occupied the Murray Islands with rights to the land and the surrounding seas since well prior to annexation and had regulated their lives by a system of rules and practices, none of which Queensland had extinguished. What follows is a very abbreviated account of what were seen as significant dates and events. The Torres Strait Islands were thought to have been first inhabited by people who migrated down via the Indonesian archipelago several thousand years ago when the Papua New Guinea landmass was joined to the Australian continent. It is likely that Chinese, Malay and Indonesian traders had visited the islands of the Torres Strait long before European explorers arrived looking for a means of passage between the Indian and Pacific Oceans. The European navigators known to have visited the Torres Strait were the Spaniard de Quiros and his second-in-command, de Torres, who sailed through in 1606. South Sea Islanders were recorded on the islands, including the Murray Islands, for some hundreds of years from the earliest history of European contact. The language of the inhabitants of the Western and Central Islands is regarded by those who are expert in these things as related to the languages of the Aboriginal inhabitants of the mainland, with some Melanesian influences. The language of the Eastern Islands is Miriam. It is quite distinct from the other languages of the Torres Strait and said to be a member of the Eastern Transfly family of Papuan languages. It was and still is spoken on Myrrh, and there is pride in its retention. The language of the Torres Strait generally is Torres Strait Creole. For some older or more reticent witnesses, interpreters were used, particularly when the court sat on Murray Island. Matthew Flinders sailed past in 1802 and had some cordial contact with the inhabitants of Murray Island. He estimated their number at about 700, but other later estimates are much lower. At no time is it thought that they exceeded 1,000 persons. In 1836, the colonial schooner Isabella had been sent to the Strait to find any survivors from the Charles Eaton, which had foundered 2 years previously. Captain Lewis retrieved 2 boys from the wreck who had been living safely on Murray Island and had learnt the language. In something of a cultural twist, Captain Lewis recorded what the local Miriam thought of the outsiders. They believe that white people live always in ships and possess no terrestrial home, and that they subsist on sharks, porpoises, and dogs. He also recorded, in a passage much relied upon by the state of Queensland in the litigation, they acknowledge no chief, each family being distinct and independent of each other. Quarrels frequently take place, which, after a fight, are generally followed by a speedy reconciliation. The pearl shell and Missionary markets led to a great influx of traders into the Torres Strait in the 1860s from many countries: China, Japan, Micronesia, and Europe. A most important event in the life of the Torres Strait occurred in 1871, when the London Missionary Society began its work on Darnley Island before moving its headquarters to Murray Island in 1876. The arrival of the London Missionary Society and its South Seas Islander teachers seem to have been welcome in the Torres Strait. Indeed, some of our informants endorsed the sentiment that it was the end of darkness and the law of the club. Many of the island's inhabitants were fierce warriors and headhunters. Ian Idris's adventure story, The Drums of Myrrh, had been read by Eddie Mabo and plainly influenced some of his more colourful claims. The arrival of the missionaries is celebrated each year on the 1st of July as a holiday in the Torres Strait and is known as the Coming of the Light. The distinguished anthropologist Dr. Jeremy Beckett, who was called as a witness by the plaintiffs, observed, "The mission offered an end to the never-ending cycle of feuding and raiding. It largely took responsibility for the law and order on the island." When Captain Cook landed on Possession Island in 1770 and took possession of the whole of the eastern coast of Australia from above latitude 38 degrees to Possession Island at latitude 10 degrees in the name of King George III, his declaration did not include Murray Island. By the 1870s, the British and Queensland authorities were concerned about the lawless behaviour of the blackbirders, the arrival of undesirable characters on the islands upsetting the native inhabitants, as well as wanting to regulate fishing in the strait and passage through it. Accordingly, letters patent were issued by Queen Victoria in 1878, authorising the annexation of the islands in the Torres Strait by the colony of Queensland. The islands became part of Queensland and subject to Queensland law from the 1st of August 1879. The judgments in the High Court in Mabo uniformly recognised that the acquisition of the islands of the Torres Strait was, for purposes benign to the native inhabitants. Prior to annexation, some administrative activity had been imposed by the police magistrate on Thursday Island in 1878, when he advised the people of Darnley and Murray Islands to pick a chief and submit to his authority, which would be supported. The title Mamos was given to the person chosen on each of the islands. He was given a boat and 6 local men designated constables. As a further measure of protection, in 1882 the Queensland Government reserved Murray Island for the native inhabitants. As a consequence, the London Missionary Society sought and obtained a 2-acre lease of the land on which the mission had stood pre-annexation from the Colonial Lands Department. This lease was regularly renewed, and when the London Missionary Society left the Torres Strait for New Guinea, it handed over the lease and assets to the Anglican Diocese of Carpentaria, which continued its occupation. That portion of Murray Island was excluded from the declarations made by the High Court. In 1888, by letters patent, British New Guinea, as it became known, became part of Queen Victoria's empire. In 1892, a Scot, John Bruce, was appointed by the Queensland Government as a schoolteacher on Murray Island. He arrived with his extended family and remained there for 30 years. He initiated and kept a register of births, marriages and deaths, participated in and kept the record of proceedings on the island court, and generally was regarded as having a good influence on the people. It became a central matter of contention in the litigation whether John Bruce merely facilitated a pre-colonial existing system for resolving disputes, particularly over land, or whether his administration was the system. In the event, this debate was largely irrelevant on the approach taken by the High Court. An important source of information about pre-contact Miriam society was the work of Professor Alfred Hayden of Cambridge University in the late 19th century. Professor Hayden was first in the Torres Strait as part of a zoological investigation for some 9 months in 1888 and 1889. He returned in 1898 with a team including musicians and linguists who recorded as much as possible about pre-contact life after 25 years of mission influence. Volume 6 of the report of the anthropological expedition to the Torres Strait is devoted to the Eastern Islands. One of his team, W.H.R. Rivers, recorded genealogies from the families on Murray Island, which, according to Dr. Beckett, led to an increased interest amongst the island residents. Practically all the adults on Murray were by then professed Christians, and all the younger ones had been to school. The oral tradition was, as Hayden observed, gradually disappearing, as were the practices of the old Bomai Malu religion. The creation myth founder of the island was Marlow, an 8-tentacled octopus. The division of Myrrh into 8 tribes or families reflected this, and you can see them marked on that map, which was drawn for Mrs. Laurie in the mid-1960s by elderly, knowledgeable men. Colin Sheehan, who is with us tonight and may never forgive me for showing this photograph, is the former John Oxley librarian, and he brought the genealogical tables from Hayden up to date during the trial of the facts. He was always extremely well dressed wherever he was. The extensive family trees were posted like a mural around the walls of Court 13 in the old Supreme Court and were viewed by Murray Islanders with much interest. The genealogies were of significance because the plaintiffs claimed their entitlement to particular plots of land through an inheritance chain of title. Gradually, some kind of self-governing system encouraged by the Queensland Government was devised and then refined throughout the Torres Strait communities. From as early as 2013, purchases of land by the Queensland Government from Murray Islanders were recorded in the Island Court record books, including for the erection of a jail, a courthouse and a recreation reserve. Subsequently, land was acquired for other public purposes. There was a rather drawn-out dispute about who was entitled to deal with the land which was sought to be acquired for the purposes of erecting a kindergarten and a preschool. And when the airstrip was proposed in the 1970s, there was much discussion about whose precious garden land should be surrendered, as the government did not intend to purchase it. In the 1930s, two Brisbane businessmen entered into a lease of Dower and Wyre Islands from the Queensland Government to build and operate a sardine factory. It was subject to the rights of the natives to use their lands for their gardens. It was a short-lived venture, but the remains are still visible. That land was also excluded from the declaration of native title. In 1936, a strike occurred amongst Torres Strait Islanders employed on island company fishing boats, reflecting general dissatisfaction with conditions and payment. Importantly, the Queensland Parliament passed the Torres Strait Islanders Act 1939, which charged each island community with responsibility for its own governance by establishing formally an island council and court with the power to make bylaws for governance in accordance with island laws and customs. Dr. Beckett visited Murray Island extensively from 1958 and revisited the work of the Haddon-Cambridge expedition to see how the Murray Island social system had responded to its contact with the modern world. It is widely accepted that Dr. Beckett left behind a copy of Volume 6 of the Haddon Report. That it was read by certain of the islanders was quite apparent. Myrrh, a very senior influential figure in the 1940s and the 1950s, who died in 1968, left a collection of documents which were produced by the plaintiffs to Justice Moynihan in the course of the hearing. These writings were said to show the continuity of pre-European contact laws about land tenure. But it was contended by Queensland that those documents included direct transcriptions from Volume 6 of Haddon, including the variant spellings introduced by Haddon and his linguist Ray to the story of Marlowe. The documents also contain extracts in Myrrh's handwriting from the genealogies contained in Volume 6. In his findings of fact, Justice Moynihan reflected, "The fact of the Marlowe story extracts is interesting because Myrrh seems to have been responsible for the dissemination of what came to be called in the course of the hearing Mabos Laws among the community. These laws, in their application to life on a small island, were sensible, and it can readily be accepted, necessary. In essence, they express that one did not venture on another's land or touch another's property. If it were necessary to do so, the intruder would ask permission. The Merriam expression, Malo tag mauki mauki, teta mauki mauki, was much recited on the plaintiff's side of the record. It means, Marlowe keeps his hands to himself. He does not touch what is not his. He does not permit his feet to carry him towards another man's property. Witnesses were asked what they would say if some unauthorised person came to their land. A number obligingly responded with Marlowe's law. But not all were so conversant with its application to daily life. For example, a witness who owned part of the waters between Myrrh and Dower Island was asked what he would say if he saw a non-family member in a boat fishing there. He clearly knew his answer was important, but finally, defeated, he offered, "Caught anything?" It is worth pausing to note that in 1966, the South Australian Government had passed the Aboriginal Land Trust Act, legislating the first formal recognition that Indigenous people had rights in land based on traditional laws and customs that existed before white occupation. It was not a recognition of native title, but an acknowledgement of moral claim. In the same year, Aboriginal stockmen walked off Wave Hill Station over pay and conditions. There was, by then, a certain restlessness about Aboriginal conditions on the reserves on mainland Australia and their petty bylaws. Closer to the Torres Strait, in 1973, the Commonwealth of Australia and the Government of Papua New Guinea began negotiating the border between the two countries. Papua New Guinea achieved independence in 1974. The Prime Minister of Australia, Mr Fraser, met with 60 island councillors and elders representing all Torres Strait people at Yam Island in November 1976 to discuss the border issue between Australia and New Guinea. Mr George Mai, the chairman of the Darnley Island Council, expressed the view strongly in 1987 that Torres Strait Islanders who had, since before European contact, dealt with the people of Papua by way of trade on equal terms, were denied a place at the negotiating table about the border because the Torres Strait was not seen as independent. This was another concerning factor for Torres Strait Islanders. Members of the profession might be interested to know that Mr Mai had been Mr Max Gore's runner during the Second World War, when Mr Gore had been posted to the Eastern Islands to look out for Japanese shipping, and in particular for submarines. The late Max Gore was a member of the Queensland Bar and father of an esteemed member of the Senior Bar. The Queensland Parliament passed the Land Act, Aboriginal and Islander Land Grants Amendment Act in 1982 to provide for a deed of grant in trust in favour of the inhabitants of Aboriginal and Islander communities. By the commencement of the Mabo litigation, deeds of grant in trust had been made to all Torres Strait Islander communities except Murray Island. It was the prospect of this occurring on Murray Island which influenced Eddie Mabo to challenge the state's power to do so. Earlier in 1970, the Yolngu people of Arnhem Land had argued before Justice Blackburn that the common law recognised pre-existing traditional rights to land founded upon the Indigenous community's prior occupation, customs and traditions which had survived colonisation. The catalyst had been the grant by the Commonwealth of an exclusive lease to Comalco for some 12 years to mine bauxite in the lands of the claimants. They lost, broadly on two bases: that the common law did not recognise the survival after acquisition of pre-existing native title in the absence of specific agreement to do so. In this, he was following binding High Court and Privy Council authority. Second, that a continuous relationship with the subject land from pre-1788 had not been established by the plaintiffs. The decision was not appealed, but it is now known that Justice Blackburn wrote to the Prime Minister and Leader of the Opposition urging recognition of traditional Indigenous land rights. This led to the Commonwealth passing the Aboriginal Land Rights Northern Territory Act in 1976. In 1978, there was another attempt to seek recognition of native title in the courts. It was legally inept. In an application to strike out the amended statement of claim, the Chief Justice, Sir Harry Gibbs, observed, "The question what rights the Aboriginal people of this country have or ought to have in the lands of Australia is one which has become a matter of heated controversy. If there are serious legal questions to be decided as to the existence or nature of such rights, no doubt the sooner they are decided, the better. But the resolution of such questions by the courts will not be assisted by imprecise, emotional or intemperate claims. In this, as in any other litigation, the claimants will be best served if their claims are put before the court dispassionately, lucidly, in proper form." The plaintiffs, assisted by their lawyers, attempted this in Mabo and the state of Queensland. They had geography and cultural continuity on their side, never having left the islands, and there was also a growing awareness throughout Australia of the considerable disadvantage which European contact had brought to the original occupants of mainland Australia. The hearing of the remitter commenced on the 13th of October 1986 in the Supreme Court in Brisbane and concluded after addresses on the 6th of September 1989. The hearing was adjourned on the 17th of November 1986 for the High Court to deal with the plaintiff's demurrer to the state's amended defence. Queensland had passed the Coast Islands Declaratory Act in 1985, in effect to remove doubt that if the Murray Islanders had any rights in the land of the islands, they were extinguished on annexation and the lands of the island became the wastelands of the Crown. The High Court, by a 4-3 majority, held the Act contrary to Section 10 of the Commonwealth Racial Discrimination Act. The remitter resumed on the 2nd of May 1989 and continued until September. A view was taken on Murray Island and evidence given by old or frail witnesses there and on Thursday Island. The newly erected community hall on Murray Island was used as a courtroom. The plaintiff's lawyers had insisted that counsel should robe formally for the hearings on Murray Island and on Thursday Island. A compromise was reached with those a little more familiar with the temperature, and a slightly less warm tropical rig without bar jacket and wig was the result. If I could just mention in the previous slide, the senior Merriam man in the right picture is Mr. Sam Passy and with his wife. The judge, lawyers and witnesses moved around the island with boundary markers and plots of lands being identified. The inspection occupied 3 days and 4 nights on Murray Island. The judge, his associate, the bailiff and 2 court reporters stayed in the medical aid post, there being no other accommodation. The plaintiff's lawyers stayed with the families of the plaintiffs, while counsel and solicitors for the state and the Commonwealth, plus an ABC radio reporter, occupied the coastal vessel Dog Eye and came to court each day by tinny. You may recognise that gentleman in the robing room on Murray Island. On the final day, a grand feast was prepared by the residents with a dance. Those dancers are reenacting the dance of the dreaded Bomai Malu cult, which of course had not been danced for many generations. The plaintiffs were continually challenged for funding, managing on special grants of aid from the Commonwealth. Hence, on every occasion, the plaintiffs' lawyers would be very pleasant to the Commonwealth lawyers. And here we see them carrying the instructing solicitor for the Commonwealth through crocodile-infested waters. Justice Moynihan found that he had little difficulty in accepting that the people of the Murray Islands perceive themselves as having an enduring relationship with land on the islands and the seas and reefs surrounding them, but that the relationship was not characterised by the spiritual or religious implications of the relationship between the land and Australian Aboriginals as disclosed in Myrrh. His Honour concluded that pre-contact there may have been more rigid social organisations and implications for land ownership than when Hayden made his observation in 1898, but ultimately found that the evidence showed only that Merriam's society pre-contact had a bias towards social order and social cohesion. In the course of the remitter, it became apparent that many of the portions of land claimed by Eddie Mabo as his by inheritance from Benny Mabo were challenged by other islanders. The principal challenger was the school teacher, the preschool teacher on Murray Island, Caroline Modee. Furthermore, the evidence of the plaintiff James Rice was perceived by His Honour to be not without controversy, and the Reverend David Passy, the remaining Passy plaintiff, accepted that the head of the family, his older brother Sam, held the Passy lands on behalf of members of the extended family group. Much of Eddie Mabo's evidence in chief was devoted to proving his entitlements to his 36 claimed portions, and much of his cross-examination was spent contesting them. As we observed rather darkly to each other on the Queensland team, if it were a case of Eddie versus Caroline, surely we had lost the case. His Honour concluded that the individual claims should be settled on Murray Island by the processes available there, including recourse to the island court. The findings about Eddie Mabo were particularly stark. Justice Moynihan did not accept that he was adopted by Benny and Marga Mabo, with the consequence that his inheritance as the heir to either or both was not established. Furthermore, he concluded that Benny Mabo did not, during his lifetime, dispose of any of the lands to which he may have been entitled to Eddie Mabo. In the event, Eddie Mabo was separately represented in the hearing before the High Court and made no submissions about entitlements. And when it came to tax the costs of the litigation, no application was made for his costs. The case was argued before the High Court just over 3 days, from the 28th to the 31st of May 1991. The plaintiffs had sought declarations that each was the holder of traditional native title only to their individual portions of land, and since Justice Moynihan had declined to make express findings about each plot of claimed land, save for negative conclusions about shrine land, reefs, and all of Eddie Mabo's portions, there was some uneasiness on the part of the plaintiff's lawyers about the sufficiency of their facts to found a successful outcome. The judges drew attention to this shortcoming. In essence, it became an invitation to the plaintiffs to consider amending their prayer for relief to seek a communal title declaration. The plaintiffs' lawyers produced the amendments on the morning of the 4th day and included Eddie Mabo in the claims. They had undertaken earlier to Queensland to make no submissions on his behalf in light of Justice Moynihan's findings against his claims. They thought, it seems, that while Eddie Mabo had failed as an individual claimant, he could seek a declaration as a Murray Islander. After objection, his name was withdrawn from the amendment. Counsel for Queensland, our chairman this evening, objected overall that declarations for the Miriam people as a community could not stand with Justice Moynihan's finding that there was apparently no concept of public or general community ownership among the people of the Murray Islands. But Mr. Caston, in reply for the plaintiffs, pointed out that Justice Moynihan had found it may be accepted on the evidence that Murray Islanders have a strong sense of relationship to their islands and the lands and seas of the islands, which persists from the time prior to European contact. They have no doubt that the Murray Islands are theirs. That was sufficient for the court's purposes. So much of the evidence painstakingly collected and presented was really not so important. The fundamental finding, not in dispute at all, was that the Murray Islanders had been in occupation of the land prior to annexation and had traditional and cultural connections to that land which continued to the present. It was the law which required some dexterous reasoning. 6 judges concluded that the common law of Australia recognises a form of native title which, in the cases where it has not been extinguished, reflects the entitlement of the Indigenous inhabitants in accordance with their laws and customs to their traditional lands. The land entitlement of the Murray Islanders, in accordance with their laws or customs, was preserved as native title under the law of Queensland. Justice Dawson dissented on the basis that the law denying the survival of native title after colonial acquisition was so well settled in Australia that to change it required the intervention of the legislature. Justice Brennan's judgment is accepted as reflecting the decision of the High Court. Chief Justice Mason and Justice McHugh agreed with his reasons. Justices Dean and Gaudron wrote a joint judgment, and Justice Dawson dissented on the fact of extinguishment. The reasoning was this: European nations in the 17th century developed rules to regulate their acquisition of territory other than by war between each other. Where there were inhabitants with a recognisable system of government, they negotiated with them. Where the land was empty of occupants, the land was taken freed from any such burden. By the end of the 18th century, the view was entrenched that those Indigenous peoples with no recognisable system of proprietary rights in land could be ignored and the land fully exploited. This was the view taken with respect to the Aboriginal inhabitants of mainland Australia in cases such as Attorney General and Brown and Cooper and Stewart. Justice Blackburn, in his scholarly judgment in Myrrh, had spoken of the subtle and deeply spiritual rules which governed the people of Gove and their land. Justice Brennan said, as the Indigenous inhabitants of a settled colony were regarded as low in the scale of social organisation, they and their occupancy of colonial land were ignored in considering entitlement to land in a settled colony. Ignoring those rights and interests, the Crown's sovereignty over a territory which had been acquired under the enlarged notion of terra nullius was equated with the Crown's ownership of the lands therein, because there was no other proprietor of such lands. The Torres Strait Islands were subject to exactly the same jurisprudence when annexed to the Crown in 1879, since they were governed by the laws of Queensland, which inherited the foundation laws of New South Wales on establishment. The discriminatory and absurd nature of the law was highlighted when regard was had to the way they lived: gardening, fishing, living in villages, inheriting land as individuals, and settling disputes. Terra nullius, no one there. Justice Brennan observed, as the basis of the theory of terra nullius is false in fact and unacceptable in our society, there is a choice of legal principle to be made in the present case. This court can either apply the existing authorities and proceed to inquire whether the Miriam people are higher in the scale of social organisation than the Australian Aborigines, whose claims were utterly disregarded by the existing authorities, or the court can overhaul the existing authorities, discarding the distinction between inhabited colonies that were terra nullius and those which were not. That was not the end of the matter, because while the rejection of the notion of terra nullius would clear away an impediment to the recognition of Indigenous rights and interests in colonial land, it would nonetheless be impossible for the common law to recognise such rights and interests if the basic doctrines of the common law were inconsistent with their recognition. Justice Brennan found the answer to the fundamental common law concept of tenure, rooted in feudal theory. When the Crown acquired sovereignty over territory, it required the radical title to that territory, that is, title sufficient in international law to exclude other sovereign claimants. It could retain the beneficial title if it were required for its purposes. It could give other beneficial rights in that same land to others, such as land for agricultural purposes. If the land were truly desert and uninhabited, the Crown would take an absolute beneficial title to the land, as well as holding the ultimate radical title, because there would be no other proprietor. But if the land were occupied by the Indigenous inhabitants and their rights and interests recognised by the common law, the radical title by which sovereignty had been acquired could not confer an absolute beneficial title to the occupied land. Justice Brennan argued that where a proprietary title capable of recognition by the common law is found to have been possessed by a community in occupation of a territory, there is no reason why that title should not be recognised as a burden on the Crown's radical title when the Crown acquires sovereignty over that territory. His ultimate conclusion was, "It is sufficient to state that, in my opinion, the common law of Australia rejects the notion that, when the Crown acquired sovereignty over territory which is now part of Australia, it thereby acquired the absolute beneficial ownership of the land therein, and accepts that the antecedent rights and interests in land possessed by the Indigenous inhabitants of the territory survive the change in its sovereignty. Those antecedent rights and interests thus constitute a burden on the radical title of the Crown." And so the order of the High Court was, inter alia, that the Miriam people are entitled, as against the whole world, to possession, occupation, use and enjoyment of the island of Myrrh, and the title of the Miriam people is subject to the power of the Parliament of Queensland and the power of the Governor and Council of Queensland to extinguish that title by valid exercise of their respective powers, provided any exercise of those powers is not inconsistent with the laws of the Commonwealth. And of course there they had in mind the Racial Discrimination Act. There was much criticism of the judgment by politicians and vested interests. It was a Hanrahan decision. We'll all be doomed. The Queensland defence, though, having been exposed to all shades of government during the 10 years of the litigation, Liberal National Coalition, National Party alone, Labor Party, could say with certainty that there was no appetite by the politicians of any stripe for settling with the plaintiffs. Let the courts decide, was the response. Other critics derided the application of the judgment reasoning to the mainland from the Torres Strait, totally different peoples ethnically and culturally. But all Indigenous Australians were subject to the same fundamental law, that they had no recognisable rights to their lands, and that was changed by this decision. The following year, the Commonwealth Government in 1993 introduced the Native Title Act, which set up a regime whereby Indigenous claimants can seek declarations of entitlement that they hold native title to specific lands. Over the years, cases such as Wick and Yorta Yorta and amendments to the Act have developed the law of native title. Most recently, in May 2015, in a claim by the Barbaram people of Atherton, the High Court affirmed that Mabo had correctly articulated the test for determining whether an executive or legislative act should be taken by the common law to have extinguished native title. Namely, was it the intention of the Act to interfere with native title rights? Some measure of the enduring significance of the Mabo decision can be seen in the observation of Justice John Mansfield on the occasion of his retirement from the Federal Court in July this year. He had presided over more than 120 native title determinations. He said, "I have observed, to the great credit of the Australian community, a very significant attitude change on the part of the wider Australian community towards Indigenous Australians. It would not be unfair to say that amongst some sections of our community there was considerable consternation when the Native Title Act was first introduced in 1993. It is now commonplace for determinations by consent to be made, recognising the traditional rights and interests of Indigenous Australians in their country. Pastoralists, local government, mining interests and others, they attend the consent determination and share the joy of them. It is a wonderful advance. Australia was not doomed and the sky did not fall in." Eddie Mabo, as is well known, died before the High Court delivered its judgment. That he was a flawed character is conceded by his own lawyers. His personal aspirations to grandeur contributed significantly to Justice Moynihan not finding him a credible witness. His claim to be the traditional ruler of the Miriam people, the Ait, a name actually personal to men of the Modi and Passi families, not a title, went so far as to seek a declaration to that effect from the High Court. But there can be no doubt that without him, the litigation would not have commenced. And if it did, it is doubtful if the other plaintiffs would or could have sustained the gruelling decade of litigation. At Kaukarinji in the Northern Territory last month, Eddie Mabo's daughter joined with Aboriginal people for the first time in celebrating the 40th anniversary of land rights legislation. Without Eddie Mabo, a suitable vehicle for the declaration that native title to land is recognised by the common law of Australia might never have been found. Thank you.
Thank you. It was, as I'm sure all of us appreciate, including quite a few people in this room who had an involvement in the litigation at different stages, a perceptive analysis of the case. It was a perceptive legal analysis, concise though it was, but more importantly, it painted a larger picture for us, that lecture, of the decision, the ramifications of the decision, and the personal elements involved in the litigation. If I may say so, it was typically eloquent and illuminating. May I ask you once again to record your thanks for that wonderful talk. With the customary generosity of the Supreme Court Library, may I, on all our behalves, offer a small token of our appreciation.
Thanks, Hugh.
Thank you. I just have a couple of formal things to say. The original photographs from the Martin Moynihan collection of photographs, which are kept usually in the Supreme Court Library, and some other material relating to the hearings in the Mabo litigation are on display in the foyer. I should also, if I may, on behalf of the Selden Society Australian chapter, remind those of you here that the annual meeting and lunch will be held on the 14th of October 2016, with Justice Martin to speak on the Brisbane bar 40 years ago. I will go so far as to say that seating is limited and will be allocated in order of payment. Those of you who are not members of the Society can easily become so. The library staff are here and will be happy to talk to you. I should also say that this lecture, like all Selden Society lectures, has been filmed and will be available in the Supreme Court Library, and our speaker will be very pleased to know that she will soon be able to be viewed on the YouTube channel. And I believe also that Margaret's paper will be published on the library's website soon. There is also a Selden Society event that I would like to give a plug for on Thursday the 27th of October. This one to be given by the Honourable Margaret Myrrh AC on Justice Sandra Day O'Connor. And finally, can I invite all guests to enjoy refreshments in the foyer now. Thank you.